Hello and welcome back to the lecture series on the subject of constitutional law. My name is Taimur Khan and I'm an attorney at law. So today we are going to discuss yet another important constitutional case, the Governor General's reference case. Earlier we discussed the famous Yusuf Patel case, where the highlight of the federal court was that firstly the Governor General could not assume the powers of the Constituent Assembly to frame the Constitution, and secondly he could not validate the laws by retrospectively giving his assent to acts earlier passed by the Constituent Assembly. Now, another interesting feature of the Yusuf Patel case was that though the Emergency Powers Ordinance, which had been promulgated on the 27th of March 1955, had not per se been challenged, been questioned before the federal court in the Yusuf Patel case, however, nonetheless, short of dismissing or set it aside, the court said that the Governor General could not assume the powers which were given to him by the ordinance, because they rather went outside the scope of the mandate of the Indian Independence Act, read with the Adapted Government of India Act 1935. So when the Yusuf Patel judgment came out on the 13th of April 1955, it came as a huge setback to the government, because not only detention orders issued under the Governors Act of 1952 were being challenged all across the country before different courts based on the Yusuf Patel precedent, but just about any sort of rights or liabilities or obligations which had been created by so many of the acts passed by the Constituent Assembly, all of them were certainly being questioned. It seemed as if that the very floodgates had been opened. So 2 days after, on 15th of April 1955, the Governor General summoned for a second Constituent Convention to meet up on the 10th of May, and the members of this new Constitution Convention were to be indirectly elected from different provincial legislatures. And one day after, on the 16th of April 1955, the Governor General, through yet another proclamation, assumed powers onto himself till such time that the Constitution Convention meets up and makes the requisite changes, the powers which were necessary to validate and enforce the laws so as to avoid the breakdown of the constitutional machinery. And these powers rather were assumed subject to the ultimate opinion of the federal court. The Governor General also, as such, invoked the advisory jurisdiction of the federal court under section 213 of the Government of India Act 1935. Now, initially the reference which was sent entailed only 2 questions. However, this reference was enlarged and a total of 4 questions were now put to the federal court under section 213, whereby the opinion of the federal court was sought. The questions were: number 1, what were the powers, the responsibilities of the Governor General before this new second Constitution Convention passes legislation? Number 2, was there any provision under the Constitution or under any law which would give such powers to the Governor General to validate the laws till such time that the Constitution Convention determines them? Number 3, whether this new second Constitution Convention as such could exercise the powers of the Constituent Assembly, and whether the Constituent Assembly was rightfully dissolved. On the question of the powers of the Governor General, the court initially referred to some of the arguments which had been made by the Advocate General and Mr. Diplock in the Maulvi Tamizuddin case, stating that the Governor General had an unqualified legal right to dissolve the Constituent Assembly, on the premise that the right to dissolve the Constituent Assembly was as much a part of the prerogative as the prerogative to summon and prorogue the Assembly. The prerogative being the residue of the discretionary or the arbitrary powers vesting in the hands of the governor, and they were relying on section 5 of the Indian Independence Act, which read that the Governor General was appointed by His Majesty and would represent His Majesty for the purposes of the affairs of the Dominion. Now, the court initially referred to the Indian Independence Act, and they said that there was no provision under this act which would give any such power to the Governor General to dissolve the Constituent Assembly. Secondly, they referred to sections 24 and 27 of the Government of India Act 1935, which dealt with vacation of seats, disqualification of members and oath of members. And since these acts were omitted in the Adapted Act, the conception was that no new elections would be held, and it would be only done so under a new legislature set up under the Constitution framed by the Constituent Assembly. So the Constituent Assembly would be the only body that would be framing the Constitution, and no other legislature was yet envisaged under the Indian Independence Act. Thirdly, the court also referred to Section 8(1), which, as we covered in our last lecture, said that the powers of the legislature of the Dominion were to the effect of framing the Constitution were to be exercised in the first instance by the Constituent Assembly. And so the understanding was that by statute, by Section 8(1), the powers or the prerogative to dissolve the Constituent Assembly, which perhaps once existed in the hands of the Governor General, were taken away by Section 8(1). The court also felt fortified by further examining Section 18 and Section 19. They said that the powers to summon, prorogue the Assembly were kept intact, minus the power to dissolve the Constituent Assembly. The court also examined various acts and constitutions of different countries, the British North American Act, Canada, South Africa, New Zealand, and other different countries, other different kingdoms or colonies under the British Empire, where similar provisions were kept intact that the Governor General could dissolve the Constituent Assembly. And so the court ultimately held on this question that the statute can take away the prerogative powers of the Governor General. Now there was another similar question related as such, whether the Governor General could indeed dissolve the Constituent Assembly even if this prerogative power had been taken away. And so the court examined it and had to see whether any such provisions which had taken away those powers, were they absolute or were they qualified? Was there any purpose which was to be served by the Constituent Assembly under the Indian Independence Act? And so the court ultimately, after going through some of the other arguments which had been heard on this point, held that under Section 8(1), the Constituent Assembly was to serve a definite purpose, which was to frame the Constitution. They have taken more than 7 years and still failed to frame the Constitution. The court was also referred to a table where different time periods were elaborated, were set out as to how much time each country took in framing their constitution. The furthest time was taken by one country, which was 1 year 3 months, and so the court held that Pakistan has broken all the records, and even after 7 years they failed. So if they failed the purpose, the prerogative powers would be construed to still vest in the Governor General in dissolving the respective Constituent Assembly. Another question was whether the Constituent Assembly was representative. You see, in 1954, elections were held in East Pakistan, and since United Front won most of the seats, it was their claim that now the new Constituent Assembly should represent the new members of the provincial legislature. The previous members are not even members anymore in their provincial legislatures, and so this has become an unrepresentative body. Another point which was made was that the various acts which had been passed by the Constituent Assembly were done so in excess of the powers as envisaged under the Indian Independence Act, because they were doing so without the assent of the Governor General. Now there was another question whether the Constitution Convention could exercise the powers of the Constituent Assembly. They said that Constitution Convention can exercise those powers of the Constituent Assembly because the Governor General can re-summon if he has dissolved the Constituent Assembly, but the name of it would be Constituent Assembly and not the Constitution Convention. Now the major question was, under what law of the Constitution or under what provision could the Governor General validate the laws which had been passed by the Constituent Assembly? This was a crucial question, which already had been taken up or dealt with in the Yusuf Patel case, but the court distinguished the two cases, saying that in the first case the Governor General was claiming all powers that he could frame the Constitution. There was no mention of any Constituent Assembly, and that the new proclamation which has been issued is a temporary stopgap arrangement till such time that the Constitution Convention figures out, gets the act figured out. The Governor General would only assume those powers up to this extent. And so they referred to the address of Lord Mansfield, and they said that subject to the condition of absolutism, extremeness, an act which otherwise is illegal would become legal under the stress of necessity, the necessity being referable to preserve the Constitution and to avoid it from a complete breakdown, from the dissolution of the government. And so this act of civil or state necessity, this doctrine, was for the first time in the constitutional history of Pakistan given in the famous reference case by the Chief Justice Muhammad Munir. Justice A.R. Cornelius gave his separate note similar to what he did in the famous Maulvi Tamizuddin case. And he, in the Maulvi Tamizuddin case, held that the Constituent Assembly was never the legislature of the Dominion. This term, legislature of the Dominion, as per his account, was a legislature which was yet to be established by a constitution which was yet to be framed by the Constituent Assembly, and so the trappings, the limitations which were set out in section 6(3) of the Indian Independence Act could not apply to the Constituent Assembly as were done so by the majority opinion of Chief Justice Muhammad Munir, because the Constituent Assembly was a supra body. However, nonetheless, since this judgment has been rendered and it is the law of the land, the account of Justice A.R. Cornelius was that we have to follow ahead with this judgment intact. Now, the gist, the main thrust of the A.R. Cornelius opinion was that in the Maulvi Tamizuddin case, the sole criteria to assuage whether the Governor General has the prerogative power to withhold his assent is to be determined as to whether there is any provision in the statute which by express words or intendment takes away those powers. So the same principle would apply here as to whether there is any provision in the statute by express words or intendment, the prerogative powers of the Governor General to dissolve the Constituent Assembly have been taken away. And so the A.R. Cornelius firstly referred to the overall powers of the Governor General. He said that the Governor General could only claim to have those powers which have been delegated to him, and they would be mainly through instruments such as the Commission of Appointment or the Oath of Office, and that he cannot claim to have any powers in excess of any powers which have been entrusted or given to him by way of delegation. But on this question, Justice A.R. Cornelius stated that in view of section 8(1) there seems to be no such provision which would take away those powers. In other words, the Governor General has the powers to dissolve the Constituent Assembly. Now the main question again was whether was there any provision in the Constitution or under any law whereby the Governor General could validate the laws. And so Justice referred to the holding of the Yusuf Patel, where it was clearly stated that the Governor General could claim no powers to effect change within constitutional law. And applying this judgment, Justice A.R. Cornelius very eloquently stated that there is no provision in the Constitution or under any law whereby the Governor General could validate those laws either on a temporary or a permanent basis. As far as the whole subject of emergency was concerned, he referred to certain paragraphs where he wanted to bring to the knowledge that the Advocate General was well aware, the court was well aware of the grounds of emergency in the Maulvi Tamizuddin case, and even in the Yusuf Patel case, a remark was made that somehow under the guise of emergency, all powers are being claimed by Governor General, perhaps even to affect constitutional law. So how come that doctrine of necessity which is being stressed here could not have been used in the Yusuf Patel case? Now the majority opinion of Chief Justice Muhammad Munir was, unlike the Maulvi Tamizuddin judgment, supported by two more judges, Justice Rahman and Justice Akram, but Justice Sharif this time also gave his contra opinion. He said that all of the cases that we have been referred to in terms of the doctrine of necessity deal with acts of war and military sort of emergencies. Never have we come across a case where under the stress of necessity, changes within constitutional law would also be made. And second, he also supported the ultimate holding given in Yusuf Patel that the Governor General could not assume the powers of the Constituent Assembly, and so he was also of the view that the Governor General could not validate the laws because those powers could only be exercised by the Constituent Assembly. So we are going to cut short our lecture here for today, and in our next lecture we will refer to the famous case of State versus Dosso, and if there are again any questions, please leave them in the comment section. Thank you very much.